You've spent years building your life in California. You bought real estate. You built a business. You saved. You did what you were supposed to do. And then one lawsuit shows up, and suddenly you're not defending what happened. You're defending what you own. Because here's the part most people don't understand until it's too late. Lawsuits are not just about fault. They're about collectability. If you look like the easiest check to cash, the pressure goes up, the settlement demand goes up, and the case drags on longer. Sometimes not because you did something wrong, but because you look like you have something worth taking. I'm Ali Talai, a trust and asset protection attorney here in California, and unfortunately I see this happen all the time. Smart people with good intentions who believed myths that sounded true but collapse the moment a real claim hits. So in this video, I'm going to expose the 10 biggest California asset protection myths that put your home, your rentals, and your savings at risk. And you need to stay to the end because myth number 5 and number 9 are the most dangerous ones. And it traps even experienced investors who think they did everything right. Myth number 1, if I have insurance, I don't need asset protection in California. Let's start with the most common one. People tell themselves that I'm insured, I'm covered, and so I'm fine. And I will be the first to say it clearly. Insurance is the first layer in the asset protection planning. It is essential, but insurance is not the entire plan. And that's because insurance only protects you if the policy actually applies, the facts fit the coverage, and the carrier doesn't find a reason to delay, deny, or limit your claim. Here's what I see constantly with real estate owners in California. You had a homeowner policy, then the home becomes a rental property. You added an ADU, but the policy, your insurance policy, never got updated. You started doing short-term rentals, but the policy doesn't match what you're using the property for. None of that is evil. It is just what happens when life moves faster than paperwork. And even if your insurance is perfect, there's another reality that I want you to keep in mind, and that is called policy limits. They exist, and California jurors can hit hard. If the claim is bigger than your limits, that extra exposure doesn't just disappear. And that is where asset protection planning comes in, because real asset protection is about layers, insurance as the first line of defense, ownership structure, visibility and privacy, and documentation that holds up under pressure. Insurance is important, but it is not the fortress. It is the front gate. All right, myth number 2, only the super wealthy need asset protection in California. This one is dangerous because it sounds humble. People say, Ali, I'm not a billionaire. I don't need this at all. But here's the truth. If you own anything in California, a home, a rental property, a small business, even a decent saving account, you can become a target not because you're famous, but because you look collectible. Let me say it plainly. Most lawsuits are business decisions. A lot of plaintiff side attorneys work on contingency. That means they invest time and money up front, and they only collect or get paid if they are able to collect anything from the other side. So they evaluate cases the way an investor evaluates real estate deals. They look at risk, they look at efforts, and they look at payoffs. And if your assets are easy to find and easy to reach, the payoff looks good. Let me give you a simple example. Imagine 2 landlords owning the same kind of rental property. Landlord A owns in their personal name, has obvious equity, and everything is searchable in 2 minutes. Landlord B has proper insurance, owns through a structure, and doesn't advertise everything on a quick public search. Same tenant, same injury, same facts. Do you think the pressure will feel the same for these guys? And I'm sure you know the answer. You don't need to be ultra wealthy. You just need to have something worth taking. Myth number 3, a living trust protects my assets from lawsuits in California. This one is everywhere. People hear trust and assume it means protection. So let me separate two things. A living trust is amazing for probate avoidance. It helps your family. It keeps things organized. It can save time, money, and stress, but a standard California living trust does not protect your assets from lawsuits. And you may ask why, and the answer is because most living trusts are revocable. That means you can change it, you can cancel it, you can move assets in and out of it, and the court sees it as still yours. So if you get sued personally and lose, a creditor isn't going to say, oh, wow, it is in a revocable trust, so I could not touch it, and never mind, let's just walk away. They're not going to do that. They're going to treat it as reachable, and this is why I tell clients a revocable living trust is not an asset protection tool. It is an estate planning tool, and confusing those two gives people a false sense of safety. So if you want lawsuit protection, you're usually looking at owning rentals through properly structured LLCs, layering ownership correctly, reducing visibility, and in some cases, careful, irrevocable asset protection trust, but only when it fits the real world situation, because asset protection isn't a magic, it is a plan. Now, those were the first 3 myths, but the next ones are where people usually get hurt because they try to move assets around, but put things in family names and assume an LLC is bulletproof. So let's go to myth number 4, because this is where California courts start seeing right through people. Myth number 4 is if I transfer my asset to my spouse or kids, they're going to be safe from creditors in California. This is one of those myths that people repeat like it is a clever hack. Ali, I will just put the house in my wife's name. I will transfer the rental property to my kids. I will move money around and they can't touch it. I get to hear these things, unfortunately. And I get why people think that way. It is because it feels like protection, but in California, this can backfire fast if you transfer assets when a claim is brewing or when you're already being threatened. Courts can treat it as a fraudulent transfers. California calls it voidable transaction, and creditors can potentially unwind it and go after the asset anyway. But even when there is no lawsuit pending, there is another problem people don't think about. And that is when you put assets in someone else's name, you just introduce a whole new set of risks. If your child gets sued, divorced, or files bankruptcy, that asset you protected can become their liability. So what did you really do here? You didn't create protection. You just moved the target from you to your kids now. Real planning, it's not about panic transfers. It is really about designing ownership so that you reduce how collectible you look, you keep control where it is appropriate, and create friction for anyone trying to reach your assets. That is what sophisticated planning does. It changes incentives before urgency forces you to make bad decisions. All right, myth number 5, LLCs guarantee total protection from any lawsuit. Okay, this is the one. This is the most dangerous myth in California asset protection planning because LLCs are powerful and because people form them and immediately, somehow, and I'm not sure why, they assume that they're done. The fact that they have gotten articles of organization, that they have a fully LLC in place and that they're protected. Let me say it clearly. There is no 100% shield anyways. There is only a 100% plan, and LLC is only one layer in that asset protection planning. The myth an LLC makes me untouchable, no, that is not correct. An LLC does not stop lawsuit, it does not stop claims, and it definitely doesn't protect you from your own mistakes. What an LLC can do when it is done right, it can change what you own. Instead of you owning the building directly, the LLC owns the building and you own a membership interest in that LLC. That difference matters because creditors care about one thing. How easy are you to collect against? The whole goal is to avoid being the easiest check to cash. I see three main problems when we're doing LLC plannings with client. I want to touch on that as well. Number one is LLC illusion, I like to call it. When the entity exists, but protection doesn't. Here's where most LLC plans quietly fail. People form the LLC, but they don't treat it like a real structure. They mix personal and business money. They pay personal expenses from the LLC account. They don't keep clean records. They don't follow their own rules. And when that happens, you open the door to one of the most or worst outcome, and that is called piercing the corporate veil. And that is when a judge says this LLC is basically just you. So I'm going right through it. That's what the judge says. And now the LLC didn't create any protection. It created false confidence. In your mind, it was a fortress. In court, it looked like a costume. Problem number two that I see is that LLCs don't protect you from liability that comes directly from you. And I'll explain this a little bit more. It really depends where the claim is coming from. This part is important because a lot of people misunderstand what an LLC actually does. An LLC can be a great layer of protection, but it doesn't magically make you immune from being sued personally. It depends where the liability is coming from. Here's a real example. Let's say you own a rental property in an LLC. Great job. But you're also the one who manages this property. You're the one making decisions about repairs. You're the one ignoring complaints, hopefully not. You're the one choosing not to fix dangerous conditions. If a tenant now gets hurt and files a lawsuit, they're not going to just sue the LLC. They'll sue the LLC, but they're going to sue you personally for negligent management because the claim is based on what you did or failed to do. And in that situation, the LLC doesn't erase personal liability. But here's where the LLC still matters. If that tenant wins a judgment against you personally, LLC planning can still help prevent that lawsuit from spreading across your entire real estate portfolio. So even if you get hit personally, a properly structured setup can help make sure property A's lawsuit doesn't infect property B, and one claim doesn't turn into a portfolio-wide disaster. That is the real purpose of LLC planning, containment, and separation, not a free pass. All right, problem number three. This is something I get to see often when I'm doing asset protection planning, and that is the single-member LLC problem. This is where California gets unique and where a lot of investors get blindsided. Many investors form single-member LLCs because they're simple, one owner, easy taxes, and easy setup. At least that's what they think. But in the real world, single-member LLCs can have weaker leverage in some situations because the original logic behind strong LLC protections was designed to protect partnerships. Situations where there are other members whose interests the law doesn't want disrupted. They didn't do anything. Those are the members that weren't involved in the lawsuit. When it is just you and there is no other partner, the whole partner protection argument gets weaker. That doesn't mean a single member LLC is useless. It means you should not treat it like a bulletproof armor. This is why, depending on the situation, an attorney might recommend multi-member structure for your LLC, having layered ownership, for example, having a Wyoming holding company involved in the structure, stronger operating agreement, that should always be with any structure that you have, better entity hygiene, because asset protection isn't about forming an LLC, it's about building leverage. The bottom line is that LLCs are excellent tools, But the myth is thinking the LLC alone guarantees safety. A strong plan requires proper insurance, correct ownership, strong operating agreement, and a system that holds up under pressure, because the real goal isn't winning a lawsuit. The real goal is not looking collectible in the first place. Myth number 6, California's homestead exemption will protect my house from any creditor. California does have something called the homestead exemption, and yes, it can protect some of your home equity in certain situations, but here's the myth. People hear homestead exemption and assume that their house is untouchable. That is not how this homestead exemption works. The homestead exemption can help in the right scenario, but it has limits, and it doesn't apply the way most people think. For example, it doesn't stop your lender from foreclosing if you don't pay the mortgage. It won't protect you from every type of creditor. And depending on the situation, it may only come into play in specific legal contexts like bankruptcies or forced sale. So yes, the homestead exemption can be part of your protection plan, your asset protection plan, but relying on it as your main strategy is risky, especially if you have meaningful equity in your home. Think of it as a helpful layer in the asset protection, but not a force field. Myth number 7, if I put all my assets in my spouse's name, I'm protected in a California lawsuit. This is one of the most common ideas I hear, especially from business owners and real estate investors. They will say, Ali, I will put just everything that I own in my spouse's name and I'm going to be safe. Here's the truth. In California, it is not that simple, and that's because we're a community property state. So just changing the name on title doesn't automatically change who owns the asset under California law. But here's the important nuance most people miss. Sometimes shifting certain assets to the spouse who has lower risk exposure can be smart strategy. For example, if one spouse is a business owner, a landlord actively managing properties, or in a profession with higher lawsuit risks, and then there's another spouse, hopefully his or hers, and that spouse has significantly lower liability exposures. So then holding certain high value assets in the lower risk spouse's separate name may reduce overall risks if it's done correctly. And done correctly usually means a properly drafted separate property agreement, and making sure that that agreement, or better, a memorandum of that agreement, is recorded so third parties are on notice. Because without that, creditors and courts can still treat the assets as community property, even if the paperwork looks different. Now, here's the part that people don't think about when they do this kind of planning, and that is, even when this strategy is done correctly, it can backfire if the couple end up getting divorced down the road, because what protected the asset from one risk can create a different risk inside the marriage. So this is not a quick fix strategy. It can be effective, but it has to be intentional, documented, and weighted against real life outcomes. All right, so those were myth number 4 through number 7. And if you're watching this thinking, okay, Ali, I get it. Insurance matters, LLCs matter, and even spouse planning can matter, but only if done the right way. I'm glad. That is very good, because the biggest mistake people make in California is thinking asset protection is one magic move, that they just have to do one thing and all of a sudden they have asset protection. That is not the case as you could see it. But the next myths are where people really get blindsided because they assume that they don't have a business, so they're safe. Or if I formed an LLC or a trust, I'm automatically protected, or asset protection is something shady. So let's hit the last 3 myths, because myth number 9 is where a lot of people realize the hard way that the documents and the contents of them matter more than the label. All right, myth number 8, I don't have to worry about lawsuits because I don't have a business. This myth is one of the most dangerous because it makes people feel safe right up until the day they're not. They think, I'm not running a business, so I'm not exposed. But in California, lawsuits don't require you to be an entrepreneur. You can get sued as a homeowner, as a retiree, as a driver, a dog owner, a landlord, or someone who hosts and likes to have people over their house. And if you own rental property, you already have a built-in exposure because real estate creates contact points with others, with your tenant, vendors, contractors, delivery drivers, neighbors, and even people that come to visit the neighbors and your property. So no, you don't need to own a business to be at risk. If you own assets in California, you need to plan like a responsible adult, not like someone who thinks lawsuits only happen to other people. Myth number 9 is if I form an LLC or an irrevocable trust, I am automatically protected. This one is a silent killer because it gives people false confidence. They say, Ali, I'm good, I have an LLC, or I'm protected because I set up an irrevocable trust. But here's the truth. In asset protection, the structure's name is not the protection. The paperwork is. The content of the paperwork and the agreement is. LLCs is not the LLC, it's the operating agreement. Most people think an LLC is a shield just because it exists, but the operating agreement determines things like who's going to control decisions, whether distributions are mandatory or discretionary, what happens if there is a creditor issue, whether someone can be forced out or in, whether the entity can be dissolved too easily, and whether a member can withdraw capital contributions without approval. And if the operating agreement is generic, sloppy, or copied from the internet, it may quietly give away the protection you thought you had. Same thing with trust. People hear irrevocable trust and assume it means lawsuit proof. But what really matters in irrevocable trust planning for asset protection is we want to know who are the beneficiaries, who controls distributions. Do the beneficiaries have an absolute distribution right or not? What powers the person who created the trust kept, and whether the trust was drafted in a way that actually matches California law. Because if the trust is designed wrong, or if too much control was kept, the trust might not do what you think it does when the pressure hits. The real takeaway here is that asset protection is not about collecting entities like trophies. It's about building a plan where the documents support the strategy matches your real life, and the structure holds up when someone is actually trying to test it. So, yes, LLCs and trusts can be powerful, but forming them is not enough. The details are the difference between protection and a very expensive illusion. Myth number 10, asset protection is about hiding things or doing something shady. This is one of the biggest misconceptions, and honestly, it stops good people from protecting their families. They think asset protection sounds shady. I don't want to do something illegal. I don't want to hide money. And that is good because that is not what real asset protection is all about. Asset protection is not about hiding assets. It's not tricks. It is not secrecy, and it is not cheating. Real asset protection is about using the laws as written to create separation, structure, and smart planning in advance. It is not a whole lot different than having insurance, using contracts, taking legal tax deductions, or putting a seatbelt on before you drive. It is responsible, and in California, where lawsuits are part of life, it is essential. Today, we covered the 10 biggest California asset protection myths, including why insurance matters, but it is not enough, why you don't need to be rich to be exposed, why a living trust avoids probate but does not stop lawsuits, why transferring assets to family can backfire, why LLCs are powerful but not bulletproof, why the Homestead exemption helps but does not solve everything. Why put it in my spouse's name requires a lot more attention to detail and its drawback. Why you can be sued even without a business. Why the documents behind the LLC or trust matter more than the label, and why asset protection is about planning and not hiding. And if you want to protect what you built, the best time to do it is before you're forced to do it. Most people don't lose assets because they did something reckless. They lose assets because they believed the wrong assumptions and waited too long to get serious. In California, you don't need to be rich to be exposed. You just need to own something valuable and be unprepared. Now, asset protection is only one piece of the puzzle because protecting your assets is important, but protecting your heirs is a whole different level. So make sure you watch my next video called Legacy Planning, Protect Your Heirs from Themselves and Others in California. That video is a must-watch if you want to keep your family's future safe from courts, creditors, divorce, bad decisions, and the people who come into their lives later. I'm Ali Talai. Thank you for watching this video, and I look forward to seeing you in the next video. Click over there.